This training will be touching on the fundamentals of renting in Idaho from the perspective of individuals that may be home sharing. This presentation is brought to you by Jesse Tree in partnership with NeighborWorks Boise. What does it mean to rent a home or apartment? A leasee, also known as a tenant, is committing to temporarily live in a rental unit owned by the lessor, landlord, for the duration of a rental contract or a lease agreement. During the period of the lease agreement, the tenant is agreeing to follow all of the rules indicated in that agreement, and by signing it, the tenant contractually agrees to be evicted from the unit if they violate those rules outlined in that agreement. Tenants will be given access to any amenities outlined in the lease agreement or otherwise indicated by the landlord. Ways that you can protect yourself as a landlord or rental unit property owner. First, you can start by understanding your rights as a landlord, but also understand their rights as tenants. Be clear with your expectations as a landlord throughout the lease signing process and beyond. Know which agencies to notify when certain emergencies occur, such as power outages, damage from natural disasters, black mold or insect infestation, etc. Another strategy is to document everything. If a tenant requests a repair, document how they made that request, the date and time of the request, and the outcome of that request with only objective details. Another strategy is to make sure that you are not violating any city ordinances. Be mindful if the city of the rental unit has any laws or ordinances that control anything such as rent increases, application fee caps, etc. And lastly, communication is truly key. Provide frequent updates when there is any work being done on the rental unit, especially if a tenant is continuing to live in the unit. Never assume that a tenant should just know something. Always communicate issues and give tenants an opportunity to rectify any unwanted actions. These can include things like loud parties, parking in your neighbor's spots, not picking up pet waste, leaving cigarette butts that get blown into neighbors' yards or patios, etc. So one thing to also consider about the state of Idaho is that verbal leases are legal. Just keep in mind there are risks for both parties that are involved. If you agree to a verbal lease agreement, make sure that you are maintaining consistent and respectful communication. Don't be afraid to ask questions and get clarification. Always provide a receipt when you receive a payment or have some way to track when payments are made and for how much, whether that's looking at your Venmo transactions or bank statements. Also, let your tenant know how you will be keeping track of their payments. And lastly, let your tenant know how you plan to notify any rent increases. It is very important that as a landlord, you are understanding your and their rights. Tenants have the right to peaceful and quiet enjoyment of the property. This means that the landlord needs to ensure other tenants are respectful. Tenants have the right to a move-in sheet provided by the landlord to report any damages. This helps ensure the tenant will not be unlawfully charged for items considered normal wear and tear or false damage claims. Tenants have the right to privacy. This means that landlords need to provide tenants appropriate notice prior to entering the home. Appropriate notice should be outlined on the lease agreement. Tenants have the right to have their entire security deposit returned to them minus a reasonable cleaning fee and damages beyond normal wear and tear. From the landlord is what the Office of the Attorney General considers ordinary wear and tear versus damage and excessive filth. So under ordinary wear and tear, which are the landlord's responsibility to cover, that could include faded curtains, carpet and paint, water-stained linoleum by the shower, minor marks on or nicks in wall, moderate dirt or spotting on carpet, moderately dirty blinds or curtains, warped cabinet doors, minor marks on or nicks in floors, worn out thermostat on dryer, mineral deposits in the toilets, stains on old porcelain fixtures, or black spots on mirrors. What falls under the category of damage and excessive filth, which are the tenant's responsibility to cover and can come out of the security deposit, can include cigarette burns in curtains and carpet, broken tiles and torn linoleum, excessive wall damage, pet damage to carpet and curtains, missing or broken blinds, sticky cabinets and water-damaged interiors, water stains on wood floors, broken dryer or washer, plugged toilets and other plumbing, grime-coated bathtub and toilet, or mirrors with makeup or hairspray. Tenants have the right to have their security deposit returned within 30 days of vacating the premises. If there are any charges taken out of the deposit, the landlord needs to provide a written document listing the amount of each deduction and how that deduction was spent. Tenants have the right to be informed of any increase in rent before the due date. This applies to month-to-month leases. Rent should not change when a lease is active. An increase of 10% or more requires at least a 30-day notice prior to the payment date. Tenants have the right to call local government for health code violations. This includes mold, insect, or pest infestations. If a landlord refuses to remedy any health code violations in the home, it is encouraged that tenants do not attempt to withhold rent payment. Instead, they should report the violation to the city. Tenants have the right to have their electrical, plumbing, heating, ventilation, fire alarms, and sanitary facilities in solid working condition. If this is not the case, the tenant needs to notify the landlord in writing, and if the issue is not addressed within 3 days, the tenant has the right to sue for damages and personal injury. Tenants have the right to their personal possessions. Landlords cannot remove a tenant's personal property. If a tenant refuses to vacate the property, a sheriff must be called to make the removal. Tenants have the right to receive a receipt for any payments they make to their landlord. This includes deposits, monthly rent, as well as any late fees. We recommend all tenants receive a receipt for any payments made. Tenants have the right to a 3-day notice, not including weekends or holidays, and a lawful eviction process through the court. In most cases, the tenant has the right to use this time to remedy the lease violation or pay the rent due and may resume the lease as planned. Tenants have the right to sue their landlord for violating agreements in their lease or for violating tenant rights. Most of the time, if a violation of tenants' rights is written into a lease, the entire lease is invalidated. Looked at tenant rights, we are going to take a closer look at landlord rights. Landlords have the right to receive the full amount of monthly rent by the specified due date, which is indicated in the lease agreement or rental contract. Landlords have the right to receive the premises back after the end of the lease. Landlords should be able to re-enter and take possession of the premises after the lease term has been completed unless a new lease is agreed upon. Landlords have the right to lawfully evict their tenants. If rent is not paid on time, if the tenant is in violation of the lease terms, or if the tenant is unlawfully using, producing, or delivering a controlled substance on the premises, the landlord can go through the process of a lawful eviction. Keep in mind, any eviction must be lawful with adequate notice and through the court process. Landlords cannot simply change the locks. Landlords have the right to enter the property to make repairs after they have given the tenant proper notice. The amount of time is not specified by law, but it should be agreed upon in the lease terms. Landlords have the right to set their rent, deposit, and late fees. However, these fees should be written out and agreed upon in the lease and cannot change until the end of the lease terms. Additionally, there is a $30 legal cap on application fees in the city of Boise. Landlords have the right to outline their lease terms, though they should be open to a negotiation of those terms with their tenant. There should be a period of healthy, open communication and negotiation between the tenant and landlord prior to signing the lease. Terms must be reasonable, cannot revoke tenants' rights, and cannot discriminate against any protected classes. Protected classes include sex, race, color, religion, disability, familial status, or national origin. Sex-based protections include protections against discrimination based on sexual orientation and gender identity in Ada County. Landlords have the right to pull an applicant's credit report as long as they receive written consent from the applicant. Landlords are required to provide the credit reporting agency's name and address if requested by the applicant. Landlords have the right to deduct charges from the tenant's security deposit if damages are beyond normal wear and tear. Landlords have the right to require a 30-day notice prior to their tenant ending a month-to-month lease agreement. Landlords are also required to provide a 30-day notice to the tenant if they would like to terminate a month-to-month lease or increase the rent over 10%. We are going to be spending some time talking about how to create a lease agreement. There are a lot of different ways that you can create a lease agreement. I always encourage potential tenants to read through the lease agreement and ask questions before signing. So the more in-depth your lease agreement can be, the better a tenant can understand what questions they may have. Because once a tenant has signed that agreement, they will be locked into the terms for the duration of the lease. So it's very important that they're not committing to something that they don't understand. So some considerations about lease agreements. There are certain rights established by Idaho law that cannot be avoided by the lease. These rights include the right to privacy, the right of quiet use and enjoyment, the right to safety and health, the right against discrimination, and the right to possession of the premises. So here is a sample lease agreement that I found online. So there is no template that all landlords or rental property owners have to use in the state of Idaho. So there is truly nothing stopping you from just downloading a lease template from the Jesse Tree website for a month-to-month lease agreement, or from a reputable PDF distributor for legal documents. There are some landlords that prefer to handwrite their own. Some landlords work with attorneys that may be able to provide one to them. So this is just a very simple standard lease agreement that I found with a very basic Google search that I want to kind of use to showcase the different elements that should be on a lease agreement or any type of rental contract. So starting out, you definitely want to make sure that the lease agreement or rental contract is dated. It has your name or the property owner's name. It has the name of the potential tenants that are going to be signing the agreement. It indicates what type of premises the unit is, whether it's a house, apartment, condo, just a room, including the physical address that the property is located at, and any amenities that may be coming with it, such as furnishings. So now that the basics of that are kind of touched on in the very beginning of the lease agreement or rental contract, we want to look at the term. So term usually refers to the time duration of the lease, and the dates must be outlined in the lease agreement. So for example, if you are going to be renting a room to an individual for 6 months, you definitely want to make sure that the beginning date and the end dates are located somewhere on your lease agreement or rental contract. The lease should also clearly outline how much rent is, how rent should be paid, when it should be paid by, and who it should be paid to. So this section is good if you are very specifically only wanting to accept rent payments via, Zelle or Venmo or cashier's check, or however you would prefer rent to be paid. Making sure that that is clearly outlined in the lease agreement or rental contract, as well as any deadlines that you may have. So, for instance, if you would prefer rent is paid by the 1st, but you will allow a grace period until the 5th, that is something you would definitely want to express in the rent section of the lease agreement. Proration is most often implemented during the very first month of the lease, unless a tenant is moving in precisely on the 1st of the month, or if a tenant breaks the lease early and are paying the final month of rent. So proration fundamentally is splitting the cost between the landlord and the tenant, so the tenant isn't paying full price for a month of rent that they were not using, like they didn't have access to the unit for the full month. If you have any sort of proration standards, or if you would like to provide a calculation on how you calculate prorated rent, that would be really good to include in your lease agreement to just make things as clear and transparent as possible. Fees should also be clearly defined in the lease agreement, which can include late fees and details of when those fees will be incurred. So just this basic internet lease agreement template that I found, it includes fees on bounced checks and late fees and things like that. It is encouraged to have any type of fees clearly outlined in the lease agreement or rental contract in advance, so that tenants can have an opportunity to ask questions and get clarification before they actually sign the document. For tenants who have bad or no credit, a landlord may ask for a cosigner or guarantor who will be responsible for paying rent in the event that the tenant cannot. Cosigners or guarantors must consent in order to be added to the lease, and it does typically warrant a follow-up conversation before allowing the tenant to sign the lease. Some landlords handle this by having the cosigner attend the lease signing appointment with the primary tenant, and for other landlords, a simple phone call will suffice. So that is personal preference, but it is required that if it is someone that has bad credit or no credit and you don't feel comfortable leasing to that individual without a cosigner, making sure that that person's name is also on the lease agreement. So if the tenant will be responsible for paying utilities, that must be expressed in the lease agreement. And the security deposit section should include information on how the security deposit will be managed, as well as how the security deposit can be returned. The security deposit should be returned to the tenant upon moving out, and if not, the landlord must provide an itemized ledger of how the security deposit was used to repair whatever damage was caused by the tenant. It is always a good idea to educate potential tenants on your unit's guest or visitor policy to avoid any potential lease violations for letting someone stay with them for too long. Some landlords have a 1-week policy, some landlords have a 2-week policy, such as if a relative is in town and they let them sleep on their couch for a week, would that be in violation of the guest or visitor policy and things of that nature? Any maintenance and repair expectations should also be outlined in the lease. Some landlords prefer that their tenants text them or call them directly when repairs are needed. Other landlords prefer that the tenant submits a maintenance request through a very specific online portal. So making sure that it is clear for your tenants to know how they should make repair requests in the lease agreement. Easier for the tenant to do things in the way that you would prefer. Also, any exceptions or accommodation processes should also be outlined in the lease, which includes the military clause or any sort of reasonable accommodation regarding equal housing opportunities and things of that nature. Alterations, such as painting walls or cabinetry or creating multiple holes in the walls, can lead to tenants not getting their security deposit back. So it's also very helpful for tenants if you include a section on the lease agreement or rental contract that specifically touches on what alterations are or are not acceptable for the rental unit and what policies or processes you would like the tenant to follow if they are needing to make an alteration to the rental unit. Pet policies are often strictly enforced and can lead to an eviction. Service animals are not the same as pets and cannot be considered as such. Asking tenants to complete an inspection checklist upon moving in can make it easier to track how much of the security deposit needs to be returned to the tenant by the end of the lease. Also, be clear in your lease if you will require renter's insurance to cover specific types of damage, such as fire or flood insurance. The specific parameters of the insurance plan should be outlined in the lease agreement. In Idaho, subletting is legal unless the lease agreement between the landlord and the original tenant expressly prohibits it. When a sublease exists, the original tenant is solely responsible for fulfilling the terms of the original lease with the landlord. So again, just making sure that you're being very clear about your policies in the lease agreement. Be transparent and consistent with your right of entry guidelines on the lease agreement so that your tenant can have a good idea of what you will need from them when you do need to enter the unit to make repairs or address any other concerns that the tenant may have brought to your attention. Landlords must disclose if the unit may contain lead paint on the lease agreement in the state of Idaho. So only the parties that have signed the lease agreement or the rental contract are held to the contract. So this should include all roommates. Any additional rules and regulations must be presented to the tenant at the time of the lease signing or be present within the lease itself. So this is a rental inspection checklist that is available for free in the Landlord and Tenant Rights and Responsibilities Manual by the Office of the Attorney General. This inspection is what determines the damage that will be measured upon move out, so it's important that all parties are being honest but also realistic. The checklist should be filled out twice, once during move-in and again during move-out. Just a reminder to always get all agreements in writing. And keep in mind that you are your own advocates. Tenant rights and landlord's rights rely on each other. These rights benefit everyone and make sure that all rights are respected. We always have the option to be kind to each other. Here are some legal resources if you are wanting more information about anything that was presented in this training. My name is Cassandra Artukovich. I am the Operations Manager of Jesse Tree. Please feel free to send any questions to office@jessetreeidaho.org or call or text the Tenant Resource Center at 208-383-9486.